Good afternoon everyone and welcome to the Sparke Helmore Workplace Relations webinar. Today we're talking none other than the Bendigo TAFE versus Barclay case, which was handed down in the High Court on Friday. Perhaps the most significant test case for adverse action since it was introduced under the Fair Work Act. My name is David Bushby from BRR Media, and today I'm here and pleased to be joined by our panellists today. Firstly, David Davies from Sparke Helmore's Workplace Relations and Safety Group. Welcome, David.
Thanks, David. Good to be here.
And Stephen Sasse also joins us. He's a consultant specialising in the construction and mining industry. Welcome, Stephen.
Thank you.
And we're also joined by Vice President Graham Watson from Fair Work Australia. Graham, thanks for joining us.
Pleasure, David.
And we also have some apologies from Chris Merritt, the Legal Affairs Editor at The Australian, who sends his apologies. Unfortunately, he's unwell today. I'd like to also welcome you, the viewers here today. Thanks so much for joining us. We're going to be going for about 30 minutes. We'll be exploring the case's journey through the High Court. We'll of course be looking at the decision that was handed down on Friday. We'll also be looking at the implications for business and employers, and we'll also get a few insights from VP Watson into some of the cases and trends that are happening in Fair Work Australia. Anytime during today's webinar, please feel free to send a question through and we'll deal with those at the end of the webinar. There is a panel that's below, or that's in the screen that you have in front of you, so feel free to use that question panel. Just press submit button once though. There's no actual confirmation that you've sent the question, so once you've pressed that button, rest assured we do have your question, we'll get to it. Okay, enough from me and enough housekeeping, let's dive straight into it. David Davies, can we kick off, I guess, with the case's journey to the High Court and a wrap of Friday's findings?
Well, the brief facts, David, were these, that Mr Barclay was an employee at Bendigo TAFE, and he was also, he had a union role there. He was president of a sub-branch of the Australian Education Union. Now, Mr Barclay sent an email to union members, and he sent that in his capacity as his union role. That email was concerning to Bendigo TAFE because it made mention of some alleged fraudulent conduct in connection with an accreditation audit. So his employer, Bendigo TAFE, commenced disciplinary action against him. They stood him down on full pay. And they gave him a show cause letter asking him why disciplinary action ought not be taken. Now he said that that meant that adverse action had been taken against him because of a workplace right, the workplace right being his union membership and his right to participate in union activities. Now the matter came on before a single member. Bendigo TAFE was originally successful, then it went to the full federal court, and by a 2-to-1 majority that was overturned. The employee was successful, Mr Barclay, and it came to the High Court, decision overturned again, and so the employer was ultimately successful. The key issue though, David, was really around there's a presumption that's contained within the Fair Work Act. It's at section 361. And really what that says is that unless Bendigo TAFE could prove otherwise, it would be presumed that the adverse action was taken because of the prohibited reason of union membership. So they had to rebut that presumption. And that was really the key matter. The full federal court said in relation to the decision-making process of the Chief Executive Officer of the TAFE, who gave really very clear evidence that the decision to take the disciplinary action had nothing to do with the prohibited reason. She was cross-examined at some length, and her situation was, look, my decision really had nothing to do with union activities at all. That was irrelevant to my decision-making process. The federal court said, well, when you're looking at that, what you need to look at is the real reason for a person's conduct. And just because the person asserts what their real reason was, and even if they genuinely believe that that was the real reason, that may not be the end of the matter. And the real reason may be either conscious or unconscious. So the search for the real reason can involve a search into the unconscious mind of the decision maker. Now the High Court said no. The real task when we're looking at what the reason for the taking of the adverse action is that, frankly, it's a question of fact. It's a case-by-case approach, and that direct testimony, such as was given in this case, can be reliable as long as it's not otherwise rebutted. And I thought Justice Hayden's comments were interesting. Justice Hayden was quite critical of this split between the conscious and the unconscious mind. And he ultimately came to the view that that split between the conscious and the unconsciousness of the decision maker's process is not defensible. It's an indefensible approach. So the appeal was allowed and the employer was successful.
Well, there certainly was a lot of attention on this case. A lot of employers in particular were really looking at this and looking forward to Friday's decision. In terms of expectations, Stephen, I want to bring in you here. Was this outcome expected from your perspective?
I think most employers would have been very surprised had the outcome been any different, because the logical continuation of the full federal court view is one that a court can somehow delve into the unconscious mind of the employer, which sounds terribly Freudian to me. And secondly, it makes the employer's position completely unworkable in having any kind of managerial control over his or her workforce, regardless of whether they're union vice presidents of branches or anybody else.
David, what about you? Were you expecting this?
Well, I was hoping for it, David, because it would have been difficult to give advice, I think, because I'm giving advice to my client, and my client says, look, the reason for our decision to terminate employment had nothing to do with, say, the fact that the employee was away on parental leave. That was irrelevant. And the paperwork says that, and I firmly believe it. So I would have had to say, that's good, appreciate you believe it, appreciate the paperwork says that. Let's now look at your unconscious mind, as Stephen says. And the client says to me, well, hang on, I need a lawyer, not a psychiatrist.
Yeah.
So it's certainly made the task easier for me from a selfish point of view, but I think it's made the task for decision makers that much easier as well. I think it was going to be unworkable for a decision maker to make a clear decision for us to give advice on it. So it was the right decision in my view.
Indeed. Well, VP Watson, I wanted to just ask you this question as well. I mean, were you keeping a close eye on how this decision was going to pan out, I guess, from a conciliation point of view?
Yes, definitely, because as the leading case in this area prior to the High Court decision, it figured greatly in many of the conciliations that are before Fair Work Australia. So we don't determine these matters, we only conciliate, but we endeavour to assist the parties to reach a resolution which approximates the likely outcome of the matter if it goes the full distance. And that involves looking at the merits of a matter, testing both parties as to their respective positions and having them articulate their positions to each other, have them get an appreciation of the matter. And because it was the leading case and an area of that could be relied on by applicants in adverse action matters, it was repeatedly referred to and relied on to cast doubt on the employer's position that they were motivated by a legitimate reason. They could produce evidence about that, but the comeback on behalf of applicants invariably was no, but there might be an unconscious reason that is involved there. And that just produced a layer of uncertainty, I think, for the parties, that they couldn't really get a good handle on how the case might run, and they couldn't easily make an assessment of the likely outcome. So any clarity in the law, such as through the decision, I think assists our role in conciliating and assists the parties coming to a reasonable settlement.
Well, indeed, there was that air of uncertainty until Friday's decision, and I do want to talk about the business reaction. Before we do that, listeners, you are invited to send a message using the panel that's on your screen. We will get to those questions at the end. There are a few starting to come through, so thank you so much. Stephen, it is quite early days, only a couple of business days at least since the decision on Friday. Are you getting a sense yet as to the business reaction so far for this decision?
Well, I think the decision is upholding common sense, so most employers would welcome that. But I think you need to look at this question in a slightly broader context. Not too many employers have the time and resources to toddle off to the High Court to get these kinds of matters resolved. And indeed, many employers wouldn't even want to go to the first step of an industrial process. So I think there's a broader issue here about how effectively the system is working in a way that allows employers to manage their businesses effectively without getting sucked into this kind of milieu, because most of them, as I said, would not see it through.
David, are you getting a bit of a sense, I guess, chatting with clients over the last couple of days or so, or business in general, are you getting a sense from their reaction?
Oh, I think overwhelmingly it's a sigh of relief. But there's an understanding that the provisions are still there. People have a legislative right to make these claims. Adverse action is a very broad church. It covers, of course, not just termination of employment, but really anything to the detriment of an employee. It can cover job applicants, contractors and so on. So, you know, there's still a very firm understanding of the breadth and the scope of the jurisdiction. So, you know, this is not a great change. I think it's more of a sigh of relief from the employer point of view.
Yeah, I mean, can we draw some lessons with this case? As you said, it's a very broad-reaching area. What are the main lessons that have been learnt from the decision on Friday and I guess leading up to it?
Well, there's a lot of focus in the judgment on the role of the decision maker. So I think there's a real lesson there in that if I'm a decision maker and I've got to make some judgment about an employee's future, be it their job or whether they get a promotion or what's happening to them, if something's going to happen to their detriment, then I need to be aware that my role as a decision maker can properly be challenged. And I need to be able to back my decision. And I think as a decision maker, what I ought to be doing is having a look at myself and saying, am I truly objective? Can I make a fair decision that's going to be sustainable? Am I the right person to actually be making this decision? So I think there's an examination of the role. I think from an organisational point of view too, I think there's quite a few employers out there who might have a multitude of actual decision makers, and some of those people might not be aware that they're actually decision makers. So a person who's making decisions about who gets a job and who doesn't, for the purposes of this jurisdiction, they're a potential decision maker and their judgment can be challenged. So do we know who our decision makers are? Are they adopting a consistent approach? So that whole role of decision maker, I think, has very interestingly been put under the microscope, and we've entered the mind of the decision maker, but perhaps not the subconscious mind.
Well, Stephen, any lessons from your perspective in, I guess, in construction or mining, anything that really is drawn out from the events that have unfolded?
It's probably a more general lesson, and I strongly endorse the view that David's just put. The reason, or one of the primary reasons why the employer survived to the end of the line here is that it's clear from reading the judgment that the principal of the TAFE College was well literate, had documented things well, was relying on a strong set of public sector employment guidelines. So there was a framework within which she was able to rely on making her decisions and documenting it. And I think the key lesson for employers out of this case and out of a number of other adverse action matters that I've been involved with is the paper trail is important. Understanding how and when you can have disciplinary interventions with your workforce, how they should be documented, and what areas the flashing red lights ought to come on and you go up the line to check what you're doing is right, is absolutely important. And again, from the practical employer perspective, notwithstanding the merits of this decision, you don't want to end up at the beginning of this process to start with. So it's good to have policies, procedures and systems that prevent you from falling into that trap.
Yes, the goal is for no claim to be made, and I agree with Stephen about the paper trail. What's sometimes interesting for us is people are clear on what ought be there, but sometimes we see things that really have no place, and I'm thinking of emails. So you might have a decision-making process after an investigation, and then unhelpfully someone within the organisation starts to put their 5 cents worth in, and these emails start floating around. So we want good record keeping, but we want it on a focused basis. And we don't need these emails floating around saying, oh, and Jill just got back from parental leave, and isn't Mike a union member, and these types of things, which may not really affect the decision maker at all, but which are unhelpful for the decision maker.
Indeed. Well, some great insights, and listeners, thank you for the questions that are coming through so far. Keep them rolling through. We've probably got about another 5 or 10 minutes and then we'll get to question time. So thank you for those that have submitted so far. VP Watson, I just want to bring you in here with some observations from Fair Work Australia. I mean, how do the claims in Fair Work Australia practically work?
Okay, and I think the perspectives just given are quite valid, but of course these avenues, these remedies apply to businesses large and small. We have a lot of small businesses subject to claims of this nature, and there's a lot of, I guess, misunderstanding and confusion about the operation of the provisions. An employee might be told that they can't, for example, take an unfair dismissal action because of an insufficient period of employment or something of that nature, but they might be able to take an adverse action application. And for them, that's straightforward. They've been dismissed. Of course, there's adverse action, but they don't appreciate the other element that this is a serious matter. It's a breach of the Fair Work Act, and it is concerned with adverse action taken because of a prohibited reason. And it's that causal link which invariably is the main scope of inquiry. Someone can believe that they were dismissed because they're on sick leave, because they received the notice of termination when they're on sick leave. But they don't realise that another 15 people were made redundant at the same time by someone who was unaware that they were on sick leave. So the applications are made. We have a role, as I say, in conciliating the matter. It's important, I think, for both sides to get a very good understanding of the nature of the case. And the first step is to have the applicant identify the alleged breach. And sometimes they have difficulty doing that, and sometimes even with representation. With experienced lawyers, they have difficulty actually articulating that, working their way through these provisions. But without an alleged breach, it's difficult to see why we're all in the same room trying to resolve something. So I think it's important to get that understanding. But then, as David alluded to, and quite independent of this decision, there is and there remains an onus on the employer to disprove the allegation of a prohibited reason. So it's essential for an employer to indicate what were the reasons for the action concerned, and to explain what the evidence of the decision maker would be if the matter went to court. Not simply to come along with a standard blurb, but to indicate who made the decision and what were their reasons, and also to refute the allegation of breach against them. And if they can't do that, if there's some ambiguity and there are a whole lot of reasons involved, because it need only be one reason to be unlawful, one unlawful reason forming part of the overall decision, then there's potential liability. So that needs to be explored, and that provides a basis for an understanding of each other's positions. Then I think it's important in the conciliations to understand what lies ahead if the matter's not resolved, what sort of litigation's involved. It's in a court environment. There's probably going to be representation required. There's going to be time and effort in witnesses and all those sort of matters. They all need to be factored in by both sides. And then for the parties to make an assessment of what, if anything, they are prepared to do to settle the matter. Initially the conciliations will concentrate on the merits and teasing out those key issues, and then move to what the parties are prepared to do. And it's ultimately a matter for the parties, and if they can make whatever decisions they like, preferably with their eyes open, knowing what's involved, knowing the case against them, knowing the strength of their own case, knowing what's involved in the litigation, and they can then make an assessment. And the notion in the legislation is that in assisting the parties resolve a matter like that early, you're actually saving a considerable amount for the parties and the public expenditure that's involved in what could be quite lengthy and messy litigation.
Absolutely. Can I also get a bit of a sense from you in terms of the trend of numbers of matters appearing in Fair Work Australia? How's that panning out so far?
Well, overall, there are far more individual claims now than collective disputes of one sort or another. So the emphasis of the system does involve more individual matters. The adverse action matters are one part of remedies relating primarily to dismissals, but not confined to it. And the adverse action matters, since they were introduced in their current form, although as the High Court made clear and relied indeed on case law going back to the first Conciliation and Arbitration Act, these provisions had a genesis there. But in their current form, when they were introduced in 2009, the numbers of adverse action applications have about doubled in that time. So it's only a couple of years, but a very significant increase. Now, I don't know whether that's because there's more unlawful adverse action, or there's more awareness of the remedy, or there's more uncertainty as to outcome, so it's worthwhile making a claim. It could be a combination of all of those matters. There are still a very large amount, approximately 2,000 claims a year, using the adverse action provisions for dismissals, and a further number relating to alleged adverse actions unrelated to dismissals. And that's a matter where there's no compulsion to seek conciliation. It's an optional step. It's optional for the applicant to seek conciliation, and it's optional for the employer to participate. But nevertheless, that seems to be growing, and that figure has doubled as well in the same period.
Well, a very, very big increase, and I know we are talking about adverse action today, but I also want to get a sense from you as to any trends in other types of actions that you're seeing in Fair Work Australia.
Well, hopefully not, but for the right reasons, in the sense that if there is more certainty about standards of fairness and more commitment to fairness, then one would expect that there's a higher compliance with those standards. Where there's uncertainty, while the laws keep changing, then that tends to breed more litigation. I think actually it's desirable that people know what they can and can't do, what they should be doing, and they put their efforts into complying with that, and that it's clear when an employer, for example, has complied with its obligations, that it's not going to face litigation. But these matters have certainly, together with unfair dismissals, have been the growth area in terms of workload of the tribunal. Other matters have not increased anything like as significantly.
David, before we go to questions, does that sort of resonate with you in terms of the actions that are appearing in Fair Work Australia versus what you're seeing day to day in advising employers?
Yes, it is. And so the number of those matters that come across my desk has increased. One other thing that I've seen increase actually is under Section 550 of the Act, there's an ability for a person to be involved in a contravention. So it's sometimes not the case that just the employer is sued, but a person who's involved in aiding and abetting or conspiring in connection with the contravention of the Act can also be a separate respondent. And that's a little bit of a trend that I'm starting to see, that more and more applications are joining people. So if, for example, a decision's made by an employer and I'm, say, the Human Resources Director, and I've been involved in that decision and it's alleged to be a contravention in connection with union membership or taking sick leave or some other workplace right, then there's at least the possibility for the Human Resources Director to be joined to proceedings. So I think that's interesting. And I'm not sure that everyone's aware of that. Most people think, well, the employer gets sued, but actually individual officers can be joined by that means. That's a bit of a change.
Absolutely. And Stephen, VP Watson talked about a very significant increase in the number of adverse action claims appearing in Fair Work Australia. Is that, I guess, reflective of your industries in construction and mining?
I think adverse action is becoming another throw of the dice for the aggrieved employee. Again, for most employers, particularly smaller employers, the time and resources necessary to challenge or fight one of these claims can be something that's just not feasible. And so you cut a deal and walk away, and I think that's unfortunate. It's unfortunate in terms of employers' interests generally, and it's unfortunate because the ability for an employer to effectively discipline employees for unacceptable behaviour and conduct is a fundamental right. It's a necessity for running a business effectively. And the more that employers are scared off doing that, then the more the blow to their productivity levels and the performance of their businesses. And that's the real cost of this kind of thing.
Absolutely. Well, panellists, I think we'll wrap it up there and leave it to the viewers, for their questions. We've had a few questions come through, so please use the panel that's on your screen. Now's your last chance. Send a message, press submit, and we'll get through. We've had a few come through already, so thank you. Gents, if I can start off with the first question that's come through. It says, the High Court decision seems to rest on well-established and well-understood precedent. Can anyone suggest why the full federal court decided to ignore that precedent and instead try and set a new basis for law in this area?
Well, I can't enter the unconscious mind of the full federal court.
Well put.
I think that it comes down to the examination of the role of the decision maker. And remember, it's been done against the facts and backgrounds of this particular case. And although in this matter the employer had said, look, my decision is divorced from the union side of things and the industrial activity, when one looks at the actual email, it's written on the basis of from a union official. It's only going to union members, and there's a lot of referencing there. So I can only think that the federal court was highly aware of that and was able to make that inference that, look, I appreciate that the employer has said objective evidence that those matters had nothing to do with it, but when we look at these facts, it's not a big jump to move to that union membership industrial activity on these facts. So we've got to bear in mind that they've made the decision against this set of facts. And I think that might have assisted their honours with the process that they went through.
All right. Another question that's come through from a viewer, it says, this case is to do with adverse action and it's been decided in the High Court. Has adverse action changed?
Well, I can attempt that one again,
Yep.
David. No. The definition of adverse action under the Act hasn't changed.
Right.
Adverse action, as I think I said before, is a pretty broad church, though, and it's basically if I'm an employee, any action taken to my detriment, which the classic example is termination of employment, but could be loss of opportunity to apply for a job, could be a transfer, really anything to my detriment in the workplace. And the other thing about it as well, I think I mentioned, it's also prospective employees can be covered, and contractors as well. But the definition within the Act hasn't changed, no.
Can I just add something there, if I may, David? The definition in the Act hasn't changed, but the types of arguments as to what falls within the definition may change. And for example, and it is only an example, there have been matters that I've dealt with where someone has been terminated, but leading up to the termination there have been allegations of sexual harassment. And what has been alleged is that the adverse action included the termination, but it also included the sexual harassment. So sexual harassment in itself during the course of employment was adverse action, and because it was to the employee's detriment, being harassed at the workplace, and the reason was the gender of the employee concerned. So that was argued in a conciliation. It seemed to me to be arguable, untested so far through the courts, but it's the type of issue that is still to make its way into the courts to establish the precise reach of these provisions. Barclay concerned the ascertainment of the reasons for an action, but there are other aspects of these provisions still untested. A very small number of cases have actually gone to the courts to be tested, and there's still some uncertainty as to the reach.
All right, we'll move to another viewer question. Has adverse action become the new, I guess, quote unquote, discrimination claim?
Well, His Honour's gone to that in a sense.
It was related,
with his comment earlier, and so discrimination is prohibited conduct within the Act. So there is an ability, if one has adverse action because of a workplace right, discriminatory conduct, then that could occur. Of course, there are other jurisdictions, other acts that also pick that up, which is interesting, the interplay. And I think for those who are advising applicants about what path they might take and what sort of claim they might make, there's perhaps on one view more choice now than there may have been going back, say, 10 years ago. So there's more options, I think, notwithstanding that it's the same subject matter and sometimes the same or very similar remedy.
Well, we'll probably get to maybe one or two more questions before we do wrap up, and thank you so much for the questions that have come through so far. Another question, what would it have meant for business if this case had been decided differently?
You would be in a position where certain of your employees, particularly those who held offices within unions as shop stewards or delegates, or in this case a president of a sub-branch, would effectively have been completely untouchable from a discipline and management perspective, which would be, I think, something that employers would be horrified at. And I think, going back to the very first question, I don't think a lot changes here. I think the aberration was the full federal court going off into its land of unconsciousness, and the High Court has brought them back to some practical reality, which is something we're all very grateful for.
Absolutely. Well, another question that's come through, and this will probably be our final one. Could an employer's representative take adverse action claim against, for instance, a union that refused to meet with the company while represented by that person?
At least theoretically. Yeah. The Act makes reference to a person, a legal person. And so it could work the other way, I expect. I think it's at least theoretically possible. His Honour might know that I'm not aware of that argument being made.
Well, I think the fact that the section ropes in relationships with contractors is where that area is starting to get fertile.
Yeah, yeah. I think that's right. So theoretically possible, David.
Theoretically possible.
May have happened.
Well, they're the answers, and thank you so much. We'll have to wrap it up there, and I'd like to, I guess, finish off by thanking our panel for your insights today. David Davies, it's been a pleasure having you join us again.
Thanks again, David.
Stephen, thank you so much for joining us.
Thank you, David.
And Vice President Watson from Fair Work Australia, it's been a pleasure having you on the panel today.
Thanks, David.
And viewers, thank you so much for joining us. We've really enjoyed having your questions and your company today, and we look forward to having you join us for the next Sparke Helmore Workplace Relations webinar. Thanks again for joining us.